Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for oral argument in 1 CR 16-0123, State of Arizona versus Chavarria. Each side is allotted 20 minutes for argument. An appellant may reserve a portion of that for rebuttal. If you wish to do so, you'll need to keep track of the time on the podium clock. Out of respect for counsel and the court, I ask that those in attendance please make sure your cell phones are off or on vibrate during the argument. Counsel, we have read your briefs and conferenced this case this morning. Please keep that in mind as you present your oral argument to this morning. Proceedings are going to be recorded today, and they will be posted on YouTube. Before you begin your argument, I just ask that you please state your name and the party you represent. With that, Ms. McConaughey-Nolan, you may proceed.
May it please the court, my name is Carrie McConaughey-Nolan, along with Vicki A.R. Lopez from the Nolan Law Firm, and we are here on behalf of Isaiah Chavarria, who is not present as he is in custody in the Arizona Department of Corrections. I would alert the court, however, that actually to my right today are numerous of his family and friends who are here to let the court know that they are still in support of him and that they are interested in his case. Before I start on the substantive arguments, Your Honors, and of course I'm happy to answer any questions you have on any of the issues that have been raised, I would like, just as housekeeping matters, to alert, first off, that in referring throughout the argument to Miss Martha, and I'm not sure how to pronounce her last name, Monge, so I would preferably call her Martha, and that's not out of any disrespect for her, but it seems better than mispronouncing her name throughout. I apologize for that. Also, Your Honors, I would alert that I would like to try to retain about 3 or 4 minutes for rebuttal if possible. And finally, Your Honors, I would alert that we are not in any way contesting that this was a horrific crime or that what Martha suffered here should be belittled or that it isn't important or that this did not happen to her. What we are contesting throughout and what the evidence establishes is that this was not Mr. Chavarria who was one of the participants in it. This was a very horrific crime and kidnapping and an ordeal that she went through for several days, but that it was not Mr. Chavarria who was part of that. And we believe the evidence establishes that. Also, and finally, before getting into the substance of the various issues specifically raised in openings, Your Honor, and recognizing that the law is that issues raised in a reply are not properly raised, I would ask the court at the same time to recognize in the reply brief we have in several of the arguments addressed an issue of prosecutorial misconduct regarding what the state answered in its answering brief. And I would ask Your Honors to potentially consider that argument as issue number 9 or as an overarching issue in the case, given that it is taken to such an extreme level here in various of the arguments. As we noted in the reply, I believe in at least 5 of the arguments, there was a notation that I believe the state may be skirting what is proper for them to argue in answer. And I would ask the court to recognize that the law in this particular area isn't clear or isn't set in the sense that there isn't an opportunity for a defendant to raise prosecutorial misconduct on appeal except in a reply brief. There isn't any other time that it would come up except for when the state has filed their answer, and then the defendant would have the opportunity to say, I don't think that's proper argument. And in saying that,
okay, so couldn't you raise that in Rule 32 in a PCR?
Your Honor, I think that certainly constitutional issues that cannot be raised on appeal can be addressed in a post-conviction relief. I would say the court also has the duty, though, to try to prevent moving on to the next level if there is an error here where it can be corrected. So I think that that is the appropriate time to raise it here, is that in the reply brief, and I'm not talking, I'm sorry.
Wouldn't claims of prosecutorial misconduct on appeal require factual determinations that maybe, that we certainly don't make those kinds of determinations?
Sure. And Your Honor, for this case, for example, I would note too, I believe it's our argument 4, and I apologize if it's argument 5 instead. I would note, too, the argument regarding the state's disclosure violation below, and that is where Mr. Voiles disclosed a couple hundred pages of discovery, numerous discs, numerous audios. Some of the videos and such that were disclosed at that time were in fact in Spanish and had to be transcribed. That was all done a week before trial.
And I understand that defense counsel said they weren't prejudiced by that.
Sure, and Your Honor, and that's, in noting that, I would say I wouldn't even bring up that argument for the substance of the argument in oral argument, because I think it's a claim that is non-frivolous that can be raised on appeal. The issue there is whether there was prejudice or not. The defense attorney below said, look, I was able to get through it. I have a duty to get through this to be ready for trial, so that's what I did.
Didn't he say more than that, counsel? Didn't he say that he or his client didn't suffer any prejudice from the late disclosure?
I don't know if he specifically said we did not suffer prejudice, but he did specifically say that he had gotten through it all and that he was ready to proceed to trial, Your Honor. So, yes, he may have specifically said those words if you're quoting. And that's my point here, is that I'm not arguing that the defense attorney below didn't necessarily waive it for potentially fundamental error review.
Well, but if part of fundamental error review is whether your client was prejudiced or not, if your client's trial attorney says we weren't prejudiced, then that issue kind of goes away, then, doesn't it?
Well, I think it's still arguable, Your Honor, for the reasons as discussed in reply that, in fact, there are things that potentially can be done with that mass of a quantity of information before trial. The defense attorney is stuck in what I would call a catch-22, in that he has to be prepared for trial when he's going to trial, and so he has to get through it.
So he doesn't know whether he's prejudiced or not?
Well,
I mean, because he said we're not prejudiced. Doesn't that end the issue?
Well, Your Honor, I would disagree in the fact that I would say it's impossible to know for sure that he truly was able to digest all of that mass quantity of evidence and all of those interviews and such before trial.
He
and
doesn't
I recognize
know that.
too. Well, I wouldn't say he didn't know that. I'm saying that potentially, maybe if more thorough investigation, more time was allowed into it, he may have found more, especially in a situation like this where we're talking about numerous people who were referenced throughout those reports that didn't testify at trial and such. And there was another trial in this case on other co-defendants, that there's numerous aliases that were used and people that are referenced as a potential gang situation here. So there's a lot he may have found if he had more time.
So he may have been ineffective. I take what you're saying, and it's not a matter for us to resolve now.
Sure, and I would say if he was ineffective, that is absolutely an issue for post-conviction relief, Your Honor. I would also say that it is arguable on appeal. I don't think it's frivolous to say that there's enough evidence here from what was presented at trial, and there's enough questions that I think there is a question about whether he was prejudiced or not, which is why it was raised. But in getting to the prosecutorial misconduct in the answering brief part of it, what I'm trying to get at is not that where there's an arguable issue, or even if it's a barely arguable issue in the sense that the court may say, look, the defense attorney said there was no prejudice to him, so therefore there was no prejudice and we're going to go with that. Here what happened on answer, however, Your Honors, is that the state said, no, actually what happened below was it wasn't a discovery violation. It was the defense attorney who was acting with malfeasance in not properly raising a 15.7b motion with an affidavit. So that's where I'm talking about the appellate misconduct, Your Honor.
It appears that you may have a factual dispute with the state over what actually happened below, and it's really not something that we can resolve because we're not the fact finders.
And I understand, Your Honor, if on, for example, that issue, you're saying what's in the record is sufficient for us to affirm what happened below. Anything else would have to be discussed in post-conviction relief.
Yes.
What I'm talking about on the issue, though, for prosecutorial misconduct on appeal is the answer in saying not that, look, this was sufficiently resolved below, or, you know, there was no prejudice or anything of that nature, but rather saying I'm blaming the defense attorney below, Mr. Feldman, for not filing an affidavit in compliance with with Rule 15.7b. There clearly was that's not a factual issue, Your Honor. The factual issue here involves the prejudicial nature of what happened. It doesn't involve the fact that Mr. Voiles did fail to disclose the material. There isn't any argument that the defense attorney acted improperly in Mr. Voiles not disclosing the information to him. So if you understand on that particular issue, that's what I'm saying for the prosecutorial misconduct on appeal, arguing that no, this has been decided, so we don't need to address it now is one thing. But
so, are you specifically raising the issue of prosecutorial misconduct on appeal here
on
today?
appeal for this in particular for the discovery violation issue, I did, Your Honor, in the reply brief. I also acknowledged it or alerted the court that I thought the state was skirting that issue in a couple of the other arguments as well. So, and in the answers, blaming the defense attorney below to a further extent, the state has gotten into the habit of not just arguing that fundamental error review is what we're doing here, but arguing, for example, on the Deseralt issue, that this was raised below, but he did not specifically cite to Deseralt. Therefore, it's completely waived, and the court shouldn't even do fundamental error review. And
you say that's misconduct?
I'm saying there's no support in the law for that argument, Your Honor, in accordance with Anders versus California, in accordance with Penson v. Ohio, in accordance with the constitutions that allow a defendant his appeal, saying that you can't even look at any of the issue, that there's going into such technical argument that we're not just saying this is fundamental error review is appropriate and here's how you need to decide at court. What we're saying as the state instead is this is fundamental error. They're arguing it as something other than fundamental error. Therefore, I'm saying the court shouldn't even consider any issue at all and review it. And that's not appropriate. The court needs to review any issues. And even if a defense attorney doesn't raise an issue, the court has the duty to do fundamental error review.
Well, counsel, we may agree or disagree with your view on that. I find it very difficult to believe that that's actionable misconduct that we take notice of here.
And, Your Honor, on again, it's raised in various of the arguments in the reply brief. It's, like I said, we alerted that I think the state is skirting it in some of the arguments they make, again, because it's not just making a dispute about the arguments or dispute about the standard of review or such. It's asking the court not to even review issues. And I think that is misconduct.
Maybe if you would go through the particular issues that you'd like us to
Sure.
consider, we can.
Sure, Your Honor. In particular, I would focus on issues 1 and 2, which have to do with Martha and the motions to preclude her testimony, to preclude portions of her testimony that were informed by another person who did not come to court, who was unknown other than by the name Alejandra. And then the second motion also at the trial level, which was dealt with, which was a Deseralt motion, although he did not use the name of the case Deseralt. It was a pretrial identification issue saying don't let her identify him at trial because she couldn't identify him in the pretrial identification that occurred. So I think those are two of the biggest and best issues here. And mainly there, I want to make sure the court is clear on the facts of the case. When the trial court ruled on the issues at the hearing that had after the motions were filed on this, the court seems to indicate that this isn't something that's been dealt with before, and that it goes to the weight, not the admissibility of the testimony, et cetera. And in this particular situation, this wasn't the Martha recollecting something that happened because she's going into further detail of it later down the line. This is Martha specifically calling the police over 2 years after this case had been going and saying, hey, first of all, I've had contact from someone named Alejandra who told me that there's this guy that has a dollar tattoo and who has some other identifying characteristics, and that he was involved in this, even though she never had that information on her. She had said nothing about it.
As I read the record, though, Martha testified that she, of course, she had the contact with the anonymous informant, but she indicated that she was testifying from what she knew, and she may or may not have, but isn't that a factual dispute for the jury to resolve. She was cross-examined about that. And isn't that enough?
She was cross-examined about it, at which time the defense attorney brought out that, in fact, she was getting this information from someone named Alejandra, that we don't know what this other person's motives are and such. But that is exactly what the Confrontation Clause is supposed to prevent, Your Honor. It isn't supposed to be okay that someone comes in and testifies on direct examination as if that's their testimony, and then on cross.
What testimony are you saying was offered that is attributed directly to someone else and where she didn't say that this is what I believe I saw?
All of the specific identifying information. She had absolutely no information and nothing that indicated that Isaiah Chavarria was implicated in this crime.
Let me ask you
a
hypothetical question. If let's say there's two people who are kidnapped, and the two of them talk at some point after the kidnapping ends, and one of them remembers more than the other. Is there somehow a Confrontation Clause violation if the second one testifies? How does that turn into hearsay, or if this is simply a conversation they've had and it helps her remember something that happened, what would be inappropriate about that?
Well, I would say not much would be inappropriate about that situation, Your Honor, but that's not the situation that we have here. And that is what the trial court...
But how is that different? If she's not just parroting what somebody said and is offering a hearsay statement, this is just information that she's claiming, at least as of the time of trial, that this is what I remember. This woman helped me recollect some of the details, but why does that turn it into a Confrontation Clause? Doesn't that just simply provide an opportunity for defense counsel to say you didn't say that initially, so it looks like you're just making that up?
If that's what she had said, that would be the right answer, Your Honor, but that's not what she said. What she said was that this person, Alejandra, specifically told her what to say. And I quoted the places in the record. I have citations to it in issues 1 and 2 to the specific places in the transcripts where she said, Alejandra told me to say this. It wasn't anything that she independently recollected. And that's part of the issue that I think with the trial court.
She told me to say what in particular?
She told me about Mr. Chavarria. She
told
but
about
me
Mr. Chavarria.
His name, his identifying tattoo marks, sound of his voice, the vehicle that he was in, his nickname Queso, which came up, and so then that allowed the police to find, it was Queso that was told that then allowed them to find him through other cases out there.
So she disclaimed that she knew any of that.
She did not. Exactly. She did not know that. And they presented her testimony as if it was coming from her until cross-examination, where they highlighted that, in fact, you were told this by Alejandra, right? And she said, yes. She had no knowledge of that. She couldn't identify him, had nothing before that.
So you just said that she presented this as her testimony.
The state did.
So... Well, but she's saying that. So I don't see it because she's saying this is what I saw. Then that doesn't sound like hearsay. And on cross-examination, of course, they're entitled to bring it, but you really got that from the informant, didn't you? And either she did or she didn't. But that's a cross-examination issue much more than a hearsay issue to me.
Well, Your Honor, again, it would be if it was specifically phrased that way. But the state wasn't asking her question to say, did you specifically see this? They were just presenting it in that general format that they're having her testify that this defendant that you see sitting here in this chair is Isaiah Chavarria, right? And that's who did all of these things to you, right? Yes. They didn't get into, I specifically witnessed him doing this, I saw him. It was, I guess, more general than that in the sense that she's saying Isaiah Chavarria did these things, and then on cross-examination, she's saying, being asked the more specific question that, were you actually able to witness him? Did you actually see him? No, this was told to me by Alejandra. This is what I got from Alejandra.
That seems like good news for your client, then, if the testimony came out that way.
Well, it's good news for the client in that I think Mr. Feldman did a good job cross-examining with what he had. But the whole point of the confrontation clause is that the person who is making those assertions, who's saying Mr. Chavarria was one of the people involved in this, is the person who's supposed to be there to be confronted. Martha cannot know all the things that this Alejandra knows, who is giving her this information and telling her to say it. And on top of that is also the fact that not just Alejandra, but Martha also said she was receiving information by doing public records requests and looking at other cases, looking into the public files to find out who could potentially be associated into these cases. So she was getting information from what the police were doing in their investigation to discover things.
Are you suggesting that any time a victim has gone and looked up something about a defendant, that the victim would not be allowed to testify? Doesn't that just provide fodder for good cross-examination, that you didn't really know this, that this is something you found out after the fact?
Well, then, Your Honor, I don't understand the purpose of the confrontation clause in the first place. The person who is making that is the person who is supposed to be there. She's not supposed to be testifying to what the police say.
I'm asking specifically, a victim looks up something on the Internet and finds something on the Internet. Does that mean the victim can't testify at all?
No, it doesn't mean the victim can't testify at all. I would say she can't testify to the information that she's getting from looking it up somewhere. That's certainly hearsay.
But why isn't that taken care of with the cross-examination and saying this is not something that you learned, that you didn't recognize this person who abducted you. This is something you just looked up on the computer, and that why doesn't that satisfy the right to confrontation? Because
that leaves the jury hearing from her that she's identifying him in court, and that there's a defense attorney questioning her and impeaching her on various things doesn't alter that they've heard her identify him, that the jury believes that she has this personal information that she doesn't.
In this case, you had the pretrial identification, which was less than certain. Doesn't that provide this fodder to say that you really were unable to positively identify him during a lineup, so your identification here in court is suspect, and then she responds, and that's the argument that you make to the jury.
Well, sure, and that's what the defense attorney did, Your Honor. But that doesn't rescue it from being a confrontation clause violation or violation that she's testifying to things that aren't in her personal knowledge, and that's not what she's supposed to be allowed to do per the rules of evidence, per the Constitution. Who knows what he may have been able to find out from the person who was actually the one who witnessed the information, who is the person who could be cross-examined and confronted completely on all of this information.
I know you're out of time, but could I ask just one factual question in terms of the other witness who testified against your client, Jose?
Yes, Lizarraga.
When did he provide information to the police?
He provided information not long after he was caught, Your Honor, because he's the one who was caught during the drop of money. And he provided information that it was himself and Loretto who were the two people who conspired to commit this crime.
He implicated your client, though, early on.
I don't believe he did, Your Honor. I believe that it was only he and Loretto who were implicated within a few months. I think that then Mr. Chavarria's name came into it as potentially could it have been him, but not at the beginning of the case. And again, the victim identified him and identified the other person, Loretto, as two people involved, and then some other names, but never Queso, who it turns out is alleged to be Isaiah Chavarria. That came about years later.
Thank you, counsel.
And I apologize again for taking up more time. I apologize, Your Honor.
Mr. Simpson.
Thank you, Your Honors. May it please the Court. Counsel David Simpson from the Arizona Attorney General's Office on behalf of the state. I'll go in the same order that defense counsel did. I'll start by talking a little bit about the trial court's decision to decline to sanction the state's late discovery, and then I'll move on to issue one. To be clear, and I'm not accustomed to being accused of prosecutorial misconduct for making arguments that I think are fully supported by the record and by the law. So let's be clear about the state's position regarding the discovery violation. This is on page 38 of the state's brief. The state's initial disclosure duties are outlined in Rule 15.1, and the state admittedly failed to make timely disclosure under the rules in this case. Nevertheless, this mistake does not require reversal. Under Rule 15.7b, appellant was forbidden from seeking preclusion because he failed to certify that he pursued good faith remedies other than preclusion. That is the state's argument, Your Honor. And of course, that argument is fully supported in the text of Rule 15.7b itself, which says that no motion shall be brought under Rule 15.7a. No motion brought under Rule 15.7a will be considered or scheduled unless a separate statement of moving counsel is attached certifying that, after personal consultation and good faith efforts to do so, counsel have been unable to satisfactorily resolve the matter. And to be clear, this does not mean that the disclosure violation was somehow the defendant's fault. What it does mean is that preclusion is an extraordinary remedy, and it should only be employed when there are no other possible remedies for the error. And to that end, Rule 15.7b requires both sides to work together to seek out other remedies.
We can presumably look at the issue in the context of fundamental error, even absent the request at the time of trial. And if we're doing that, would we not simply look to whether there's prejudice to the defendant?
Either way, either under Rule 15.7, even if the error were preserved, you would have to look to see if there was prejudice. And the same would be true under fundamental error, Your Honor. And so to answer Judge Beden's question about what defense counsel said about prejudice, this is from the transcript for August 25th at page 28. Quote, I can't claim any personal prejudice or prejudice to the case. I have the information, and the 2 weeks is, I wouldn't say ideal, but I'll do what I have to with that time, end quote. So that is the defense counsel's statement regarding prejudice. The trial court...
Did he do anything further, Mr. Simpson? Did he ask for a continuance? Did he ask for anything else other than I'll read the material and I'll be up to speed?
Nothing else, Your Honor. Nothing else. And the trial court's ruling expressly relied on that representation. This is on page 29. The trial court said, well, counsel has just indicated he's suffered no prejudice and his client has suffered no prejudice. And so the trial court based its ruling upon that express representation.
And we don't know that if counsel had decided, oh, I can't look at all this material in the time I need more time, he didn't ask for that.
He didn't, and I mean, of course he could. So if he said 2 weeks is going to be enough and he gets a week in and he figures out, actually, this is a lot more material than I initially thought, of course he can object again and bring that to the court's attention and renew his motion to preclude the evidence. But he never did anything like that. Just to clarify as well, before I move on to the first issue, the state's position regarding Henderson. So the state's argument is, of course, that if the issue is evaluated for fundamental error and the defendant has not argued or asked for fundamental error, that this court need not address the issue. It still may in its discretion, but it is not required to address the issue. And that argument comes from our Supreme Court's discussion in Henderson itself. So what Henderson says is that to discourage defendants from reserving a whole card on appeal, that we are going to place the burden on the defendant to show that fundamental error occurred. And so the state's position, and I think this is supported by cases like Williams, is that, well, if a defendant has not asked for fundamental error review, they cannot meet their burden of showing that fundamental error occurred. Because, of course, how can you meet a burden of proving something if you haven't set out to prove it in the first place? So just to clarify that point, Your Honors. I'm happy to answer any other questions about the discovery issue. Otherwise, I will move on to the first issue, which regards the admission of the victim's testimony. So first,
did the victim present her testimony as her testimony, rather than what she heard from someone?
There are no statements that I can identify, and I take none that the defendant has identified where the victim presented someone else's testimony as her own.
Did she, for example, testify regarding his nickname? Did that came up during her testimony?
I'm trying to think about how this came up. I know it was made clear at trial that she did not mention his nickname before speaking to the anonymous source. So that was clearly put in front of the jury. I think you can gather from the record that she did not know his nickname until she until she talked to the anonymous source. But she never presented as if she had heard the nickname. As my recollection is that she testified that she did not hear that nickname Queso used during her kidnapping. So there's no crossover there.
What was the context in which she used the nickname during her testimony?
I don't recall if she used it at all. So if she would have used it, she would have used it in the sense of, I'm aware of this nickname now, but was not at the time. But my recollection is she made clear that she was not that she was not aware at the time of her actual testimony. I mean, I can try to look it up. It might be fairly quick to find, but my recollection was that she was asked if she had heard any of these nicknames at the time and said no. What she testified actually is that she was referring to the person who kidnapped her as Gordo, which was just her own nickname as far as I understand it. Yeah, I don't want to, I mean, I can submit supplemental briefing if the court would like, but
Counsel?
that's the best of my recollection, Your Honor.
Counsel, for there to be a hearsay objection, I'm sorry, hearsay violation, doesn't the witness have to say so-and-so told me, or otherwise make it obvious
Yes.
that she's not testifying herself, she's relaying what other people have said?
Yes, Your Honor. There does have to be a representation because, of course, the definition of hearsay is it's an out-of-court statement introduced for the matter asserted. And so if the victim is testifying that this is based on her own knowledge, then there is no statement and it flunks the definition of hearsay.
And he may be lying, I suppose, that it's her own knowledge, but that's something that can be brought on cross-examination.
Exactly, Your Honor. And that's what I take the defendant's argument to be, is essentially that the victim was lying when she said that these things were based on her own personal knowledge. That's what I take the defendant's argument to be, and our position is, of course, that that's a jury issue.
But, counsel, in my review of the record, the witness, the victim in this case, testified, from my recollection, and I'll go through the opening brief again to make sure I'm correct. The victim testified that she was testifying from her own personal knowledge. It was kind of a question. I don't know if it came up on cross or redirect by the state, but I recall hearing an answer to a question from the victim stating that everything she had testified to was from her own personal knowledge. Am I incorrect on that?
No, I think you are correct on that, Your Honor. I think you are correct, yes. So now, to be clear, there are other statements that the anonymous source is relaying to the victim that she then relays to police. So, for instance, the record suggests that the police found out about the defendant's name and his address through information that was relayed from the victim that was in turn relayed from the anonymous source. But the victim herself never testified about that at trial, of course, because she had no personal knowledge of it. Now, I would add, by the way, and this goes to some of the questions I think Judge Catani was asking, it's actually somewhat difficult to determine which portions of the record the defendant believes were not based on the victim's personal knowledge, and that's just because of the nature of the way the objection was raised below. So the defendant preemptively moved to preclude the victim from testifying entirely, or to preemptively move to preclude the victim from testifying about big swaths of information rather than objecting question by question at trial. So it's actually very difficult to identify what precisely the defendant believes that the victim didn't have personal knowledge about. But I think, as the Court has already alluded, I think the way the record presents is that it's simply a jury question. So
let's say the record were clear that there was no way she had any idea about information that she was providing at trial other than through the informant, the person who had called her, and she's making these statements as if she personally heard the reference to his nickname or the identifying marks on his arms or whatever they were. Would that be a hearsay violation?
No, it would not be a hearsay violation. To the extent it would be anything, it would be a violation of the personal knowledge requirement, but it would not be a hearsay violation or a confrontation clause violation.
What, if anything, is the remedy that the defense would have at the time she's providing information that she clearly did not know and just say she learned it from the internet, what remedy does the defense have?
I think the defense could raise an objection to that specific testimony. They could take the witness on voir dire to determine the basis for and whether she has personal knowledge or not, and then they could move to either strike testimony that had already been given or to preclude future testimony on the same subject. I think that would be the remedy, Your Honor. Just to clarify, I think there was a question about when the co-defendant identified when Lizarraga, the cooperating co-defendant, identified the defendant. Lizarraga immediately told the police about someone named Queso, a man who he knew only as Queso. He didn't identify the defendant immediately at that point, of course, because we had no photographs of him. We didn't know who Queso was at that point. Later, when the victim brought the additional information to the police and they were able to secure photographs, Lizarraga was shown a photographic lineup with defendant's picture in it and identified defendant as Queso. So that's the way the testimony from the co-defendant broke down. Last point on the first issue, I'm not sure it's technically relevant to personal knowledge, but I think it seems to undergird a lot of the arguments that are raised in the opening and the reply brief. To be clear, the police knew that the victim was receiving information from an anonymous source, but they did not know that Alejandra was the anonymous source. That's the way the testimony unfolds at trial. If you look at page 65 of the transcripts for September the 13th, quote, "I don't know who was filtering the information to her. The information we had was that Alejandra was the owner of the car." So the police interviewed Alejandra for the purpose of determining whether she was the owner of one of the cars involved in the kidnapping, but they had no information that from the victim that Alejandra was also the anonymous source.
Please not ask the victim, though, who provided this information to you?
They did ask, Your Honor. That's on page 68 of the same transcript. They apparently asked her. The answer that was initially given was the police officer. So the case agent was asked, "Did you ask Martha about this information?" The police officer said, "Well, I think in these types of investigations, kidnapping investigations, you're not going to have people come forward and give this information. They fear for their safety as well." There's a follow-up question that says, "So is that never? You didn't answer the question?" And the answer is, "Well, I did ask her, and she said that she advised me that the person does not want police contact. They don't want to come forward." So the police did ask her. I mean, that's as much as the record shows about how vehemently they asked her about it. The police did ask her, and the victim declined to say who it was. If the court has no other questions about that, I'll just touch briefly on the eyewitness identification issue, and then and happy to address anything else the court might be interested in. So first, to start with the issue of preservation. So the defendant's motion in limine below asked the court to, quote, "eliminate the victim's testimony regarding the photo lineup," end quote, and argue that it was unduly prejudicial under Arizona Rule of Evidence 403. So that's at record entry number 29 at pages 4 through 5, and then the transcript for August 25th. The only mention of in-court identification was in a single introductory sentence in that motion in limine, which asked the court to preclude a, quote, "an in-court identification and or providing any testimony relating to identifying information about appellant." The motion did not discuss the issue of in-court identification again, and it never came up at oral argument on the motion. So, and then Martha later identified the...
It stated in the motion that they wanted to preclude her in-court identification.
They wanted to preclude... No. They said it in that single sentence, yes, and they suggested that they wanted to preclude it under Rule 403. There's not only no citation to Desero, but there's no citation to Desero principles like due process or...
Assuming we want to get to the issue, your best argument for why there's no Desero violation here.
Sure. The best argument is that there's absolutely no evidence of police misconduct in creating an unduly suggestive lineup. So the Desero line of cases are going all the way up to most recently in the U.S. Supreme Court's decision in Perry versus New Hampshire, all say that the mere suggestion that eyewitness testimony or eyewitness identification might not be reliable is insufficient to preclude it under the due process clause.
And here the lineup presumably was not that prejudicial to the defendant. The victim was uncertain. Didn't say, yeah, I know for certain that this is the guy who was involved. Right.
And there's absolutely no evidence that police arranged it to be suggestive. And so any Desero claim would fail at the outset. I would add, by the way, that there's a suggestion in the reply brief that there might somehow be a different rule under state law post-Perry. That's a false distinction. Desero is not a state-created right. It is a federal right grounded in the federal due process clause. And if the court has any doubts about that, the Arizona Supreme Court's opinion in State versus Ford, which is at 233 Arizona at page 557, states that explicitly, that Desero is not a state-created right. It is a federal right grounded in the federal due process clause. So all of those cases like Perry that have come down in recent years and that have clarified that the due process clause requires a showing of police misconduct apply just with equal force to the state cases. Finally, of course, to the extent that the defendant's suggesting there's some sort of freestanding due process right to have judges screen evidence for reliability before it's presented to the jury, there is no such due process right. In our system, of course, jurors are the judges of reliability, not judges. The final point, kind of just to tie it all back in, I did not take their opening brief to be raising a 403 claim, so any 403 claim would be waived at this point, and I think the state's brief would look very different if there was a 403 claim waived here. I think we'd still prevail, but I don't think the state has had an opportunity to respond to any sort of 403 argument because it wasn't raised in the opening brief on appeal. Your Honors, I'm happy to talk about any other issues or questions the court might have. Otherwise, thank you, Your Honors. We would ask that the defendant's convictions and sentences be affirmed.
Thank you, counsel.
May I have a quick comment or two, Your Honors?
2 minutes.
That's fine.
Counsel will give you 2 minutes for rebuttal.
Thank you, Your
If we could put 2 minutes on the clock,
Thank you,
please.
Your Honors. Just to address the factual issues in particular that were raised. In the transcript, September 13th of 2010 is when Martha is testifying, and she states that she had no knowledge at all about the nickname Queso or about Queso. Also, I would just ask you to look specifically at that transcript, 9/13 of 2010, where Martha is testifying to see the answer to a lot of these questions, that police admitted to knowing the new information coming from Alejandro, but that because she wanted to remain anonymous, they didn't follow up with her or give any more. That's at 63 through 70 and 88 through 89. And then also that specifically, Martha testified that the result of the information she was provided from the anonymous source who talked to her and told her what to say is specifically at 9/7, the beginning of her testimony, 47 through 53, and then 57, and then 9/13 at 63 through 70. And that's on page 25 of my opening brief, Your Honors, are all those citations. But just to address the harm of that, where the defense attorney successfully cross-examined her, that still leaves the jury with the idea that, well, okay, so Martha didn't identify him, but somebody else identified him, so we know he was part of this crime. So that's part of that cross-examination and confrontation issue that you can't solve by a defense attorney attacking her and saying, you don't know anything about this, right? And her saying, yeah, you're right, I got all of this from somebody else. That still leaves that there's somebody else out there who supposedly identified him. So I would point that out. And as far as Perry, Your Honors, if I just may very briefly on that, note that in Perry, the ID was tainted by misconduct.
In your view, did the victim's testimony somehow taint Mr. Lizarraga's testimony?
Did it, I'm sorry, taint
Did
his?
it somehow influence his testimony? Did it have any bearing on what he testified to?
Yes, I believe it did. And there was also, in one of the footnotes, the state addressed.
What way?
By making it seem that there are other forces outside who are causing them to testify this way, that in fact he's providing information that potentially is different maybe from what he would have testified to as well, because of these other forces outside. And just on Perry, I would note, Your Honor, I'm not saying that that doesn't apply at all, just that it's a different set of circumstances. There's actual taint argued from the identification procedure itself. Here we're not saying it's the identification procedure itself, it's the surrounding circumstances, as Desirol and all the other cases talk about, in that what we're looking at is that she didn't even identify him here. So it's not that the identification pretrial was tainted, it's that there wasn't an identification pretrial, and then she went on and was allowed to identify him in trial anyway, because he's the person who looked familiar to her maybe in that lineup, and then he's sitting in the defendant's chair at trial. So that's the distinction that we were making, Your Honors, and thank you for the extra time.
Thank you, counsel. Thank you both for your briefs and presentation here this morning. We will take the matter under advisement. We will issue our written ruling in due course. At this time, the court is now adjourned. Thank you.